Good morning or good afternoon, everybody. My name is Peter Neufeld. You may have seen me before if you've attended some or one of these Lunch and Learn seminars. I'm a partner at Wagner Sidlofsky. I'm also the co-chair for this Lunch and Learn series, along with my colleague, Professor David Friedman. The subtopic that we are speaking about today is the discovery process in will challenges, which like a lot of civil litigation, it's really the meat and potatoes of pretrial activity. So it's an important topic. We're really happy that you're able to attend today, particularly given that, this is summer vacation mode and a lot of you might otherwise be on vacation. So thank you for coming out and attending today. There's an excellent blog post that was prepared in advance of today's seminar, and a link to that blog post can be found in the Zoom chat. I'll have Maddie add that. Before we begin, please have your microphones muted at all times unless you are asking questions at the end of these presentations. And then once you're done asking that question, please make sure to mute yourself again. And you're also welcome to add any questions you have into the Zoom chat. We'll be reviewing those and asking those to the presenters. So we have two presenters today, Greg Sidlofsky, who you may have seen before at these seminars. He's the managing partner of Wagner Sidlofsky and is certified by the Law Society of Ontario as a specialist in civil litigation. He will be joined by by James Dunphy, who is a partner at Wagner Sidlofsky. James practices in the estate and commercial litigation departments. He is certified as a trust and estate practitioner, and he was a former member at large of the Advocate Society Estates and Trust Practice Group. So thank you both for attending and speaking today. Big thanks to our sponsors, the B'nai B'rith, of course, Concentra Trust, Scotia Wealth Management, Torque and Mains, TD, as well as BMO Trusts and Estates. This event is free because of them. So thank you very much for that. And to all those watching today, if you've enjoyed the seminar or prior seminars, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. And the link for that, if you're interested, can be found in the chat in today's Zoom. Please also note that the certificate of attendance for this matter indicating the amount of CPD hours will be included in the Zoom chat as well. Today, we're going to have Marvin Rotrand, who's the National Director, League for Human Rights of the B'nai B'rith, speak briefly just now about the B'nai B'rith and the great programs that they're having. So, Mr. Rotrand, go ahead, take it away.
Thank you, Mr. Neufeld, and thank you to Wagner Sidlofsky for the work that you do to support us. I understand I have about 2 minutes. I'll respect the time limit. My name is Marvin Rotrand. I'm a former Montreal City Councillor. I served on council from 1982 to 2021. That's 39 years. And when I retired, it was big news in Montreal. It was all over television. I got a call from B'nai B'rith within 20 minutes offering me the post of League Director. And it was completely consistent with the work that I've done over the years to fight hate that's aimed at the Jewish and other communities. The work of the League largely focuses on getting jurisdictions to adopt the International Holocaust Remembrance Alliance definition of anti-Semitism. We were very successful in the last year. We played a major role in Alberta, Saskatchewan, Manitoba, New Brunswick, and Newfoundland and Labrador adopting the definition. When we're working with all the other provinces currently. Adoption is only one thing. Our main goal is, once adopted, to get it to be disseminated and implemented. And we provide a lot of support to stakeholders in the province so that they better understand the definition. We also liaise with the Government of Ontario very closely, and we're one of the partners that aided Minister Lecce in making Holocaust education in elementary school compulsory in Ontario, and that begins this September. We're currently working with all the education ministers across Canada to emulate that. Quebec has said no, the Northwest Territories have said yes, Manitoba and Saskatchewan said probably. We'll continue to work on it. All the figures show Holocaust education has a very major impact in reducing not only anti-Semitic incidents, but incidents of hate aimed at other racial and religious minorities. We also do a lot of multicultural outreach, partly to highlight stories. In the last couple of months, we did Jews from the Caribbean. and discovered so many Canadian Jews have links to the Caribbean. Our call had speakers in 4 different countries in the Caribbean and Canada and highlighted a common history. We also did a call recently, which was global, with speakers in the Philippines and Canada, including 2 ambassadors, 2 Canadian cabinet ministers, 6 Ontario cabinet ministers, and a host of other speakers on the historic friendship of Filipinos and Jews, including that the Philippines was one of the few countries that opened its doors to Jewish refugees fleeing the Holocaust. But it isn't only about telling stories. We'll build alliances, and 2 areas we're currently working on is to essence, combat online harms, win new legislation, and second of all, to work together towards a registry to combat malign foreign influence. That gives you a taste of what we do. I thank you for the 2 minutes, and I thank you for the ongoing support of B'nai B'rith. Thank you, Mr. Neufeld.
Thank you, Mr. Rotron. Again, it's a great program, very worthwhile. So please consider donating. We really appreciate it. All right. Again, thank you for that. We're going to start with the seminar. Today's subtopic is about the discovery process and will challenges. I understand that Greg Sadlowski is going to start us off. So take it away, Greg.
All right. Well, thank you, Peter, and thank you, Marvin, as well. Good afternoon, everyone. I'm going to start off by addressing the general differences between discoveries and cross-examination. And then James and I will alternate discussing different topics relating to examinations generally. Examinations for discovery in an action serve a different purpose than cross-examinations on affidavits that are filed on an application or on a motion. A discovery literally allows you to discover the opposing party's case. It's an opportunity to find out what the opposing party knows, where their information comes from, what they are relying on in the litigation. It allows you to get their responses to your own client's allegations, to ask questions about the documents, both theirs and your own, you name it. Discovery even allows you to get into hearsay evidence, what others have told them, or just what they believe and why. It's important to note that there is no downside risk to asking a question in a discovery, because the transcript cannot be relied on as evidence by the person being examined. And I'll address that point in more detail shortly. But because of that, you want to ask questions about issues, even if the answers may hurt your client, because you need to know what the opposing party is going to say at trial, the good and the bad. You also want to know the weaknesses in your client's case. If you don't ask for it on discovery, it doesn't stop the other party from giving the evidence at trial. So you need to know what they are going to say to avoid any surprises down the road. You also want to have their evidence in black and white under oath, so that if they say something different at trial, you can use their discovery evidence to impeach them with the inconsistencies. Another goal of an examination for discovery, aside from getting information about the opposing party's case, is to get admissions that help your own client's case. And it's extremely useful to be able to rely on an opposing party's own words to help prove your case. And as I will cover shortly, admissions made in an examination for discovery can be relied on at trial or on motions, at mediation, pre-trial, whatever hearing you're before the court. Another goal of discovery is to get evidence that you can use to attack the witness's credibility, whether it's because their memory is bad or because they are not truthful. And it's even useful just to see what kind of witness the other person is going to be at trial. Are they going to come across as credible, sincere, likable, or are they a disaster that will make your client look good? A cross-examination has a different, more directed purpose. Whereas in a discovery, you can ask any question that is relevant to the issues raised in the pleadings. In a cross-examination, you're limited to questions that are relevant to the application or motion on which the affidavit has been filed. or to matters raised expressly in the affidavit. Now, it may be a subtle distinction in some types of motions, but it can be very important for others. For example, if you're dealing with a summary judgment motion, then everything might be an issue. But if you were talking about a motion for specific interlocutory relief, then the issues will be much narrower, as will the scope of proper examination. But it's very significant to note that any party can rely on the evidence given at a cross-examination as part of their case. That means that the party being cross-examined can rely on their own evidence in the cross-examination to support their own position in court. And because of that, questions on cross-examination have to be more carefully crafted than in a discovery. And they really ought to be in the form of leading questions, unless you have good reason to do otherwise. You want to use leading questions to try and keep control over the witness and limit the witness's ability to give harmful evidence. So on a discovery, you generally ask open-ended questions because you want to know what the witness is going to say, and because the answer is not going to hurt your client. At worst, it will just inform you or waste your time. But on cross-examination, the answer can be used against your client on the hearing by the person giving the answer. So asking a question that opens the door to harmful evidence is a real concern, and you have to try to guard against that, which can be very difficult. Some witnesses go into a cross-examination with an agenda. You might ask them a very specific question about one topic, and they give you a rehearsed answer about something else. Now, it could be a very transparent attempt for them to buttress their evidence, but it can be difficult to prevent. And for that reason, in a cross-examination, you need to be very direct in your questions. Use leading yes or no questions, put statements to the witness, and ask them to agree with you. And when a witness goes off the rails or gives answers that are not responsive to the questions asked, you need to do what you can to rein them in, bring them back to the question asked, but always keeping in mind that both sides will be able to make use of that transcript at the court hearing. So now we'll turn it over to James to talk about the next topic.
Great, thank you very much, Greg. So I'm going to talk about a really important staging post in will challenge litigation, and that's the order giving directions. And it's really an order that in practice needs to be taken out in almost every will challenge proceeding. But the rule itself is permissive. So it's rule 75.061, and it states that any person who appears to have a financial interest in an estate may apply for directions or move for directions in another proceeding under this rule as to the procedure for bringing any matter before the court. So whilst it is permissive, it certainly is necessary, and we'll get into that in a moment. The wording of the rule also applies to both applications and actions. So you'll see persons may apply for directions or may move for directions in another proceeding under this rule. So obviously that applies to motions in an action. So the purpose of an order giving directions should be to get some procedural regularity, and you'll want to include a timetable which includes service of materials, examinations, and a mediation. You should also give some thought, if you're not in one of the areas where mediation is mandatory, if you want to include a mediation component. And often that's just a quick email or a phone call with counsel. But where an order giving directions really is necessary is getting productions. So on a will challenge proceeding, it's the deceased's medical records, which are almost always in play, and financial information, and the drafting lawyer's file. And that will be depending on the facts of the case, it will always be for the impugned will or wills where you'll want to see the entire file. But give some thought as to whether the deceased made any prior wills, because a departure from a prior testamentary scheme, that's an indicator of suspicious circumstances. So you'll have no trouble getting the complete file for the specific wills at issue, but consider whether you should also get a more limited form of order permitting just release of prior testamentary documents. Waivers of privilege, of course, nobody will give you that information unless you have the waivers in there. And always ask for a statement of assets and liabilities of the estate. It's rare that litigants in will challenge litigation have a full appreciation of what the assets and liabilities of an estate are. And this is a really good opportunity to get that. You should, I mean, we're talking about the production of a will drafting lawyer's file. Now they should have been served with the originating process, normally the application record. So they should be on notice that this proceeding is ongoing. And their counsel, which should be LawPro, will want to have some input into the content of that order giving directions. It's after all, you're asking for production of their client's file. But they'll also want to have some input in respect of compensation. And there's case law saying that the drafting solicitor is entitled to be paid their usual hourly rate for the time that they've spent during the examination. And it's also good practice to include, 1 or 2 hours of prep time, depending on the nature of the dispute. There's really no point getting into much of an argument about that because it is set out in the case law. And they'll also want to speak to any examination schedule that you may want to include in the order. Finally, the Rule 75.06 also allows parties to set out what the issues to be decided are in the litigation. So typically, if the notice of application is fulsome, those issues should be readily ascertainable. But if they're not, if the relief sought is more general in nature, you should definitely consider setting out what those issues to be decided are. So Greg, unless you have any comments on the order giving directions, that's over to you.
All right. So I'm going to discuss Rule 3903 examinations now. That rule allows you to examine a person so that their evidence is available for use on a pending motion or application. So even if the person has not filed an affidavit, even if they're not a party to the litigation, you can still examine them and get a transcript of their evidence for use on an upcoming hearing. The only requirements are that the witness has relevant evidence to give and that there is a pending motion or application. So you can't pursue a Rule 3903 examination just out of the blue. It has to be in support of an actual motion or application that is pending. Now, there's a potential for abuse using the rule. The opposing party may try to apply pressure by compelling people to be examined who don't want to be examined. Perhaps people who are not really appropriate, like a CEO of a business when the CEO had no involvement in the subject matter of the litigation, or a family member of an opposing party. And the only recourse is to bring a motion to strike out the summons. And to do that, you have to establish that the witness does not have relevant evidence or that the examination would be an abusive process. And that's not easy to do. But Rule 3903 is very useful if a party is trying to avoid giving evidence by having someone else file an affidavit instead. Or sometimes people with important evidence simply are not directly involved in the litigation. So you need to rely on this rule in order to secure their evidence and ensure that it's available for use in court. And you can compel a witness's attendance by serving them with a summons and attendance money, just like a witness at trial. The rule expressly allows you to cross-examine, even if you are the person calling the witness. But you have to take steps to pursue the examination with, quote, reasonable diligence. That means you can't wait until the day before the motion or the application and then ask for an adjournment because you want to examine a witness. Another technical requirement is that you need to conduct any Rule 3903 examinations before you conduct cross-examinations on affidavits. So that ensures that an affiant who actually swore an affidavit gets to know what the witness says on their examination before the affiant is cross-examined. So now, James, I think we're going to be discussing preparing witnesses for examination. Why don't you start off?
Sure. I guess at the outset, you should really try and manage expectations. The witness or the deponent or the party, they should know what's expected of them. And really that's to answer all proper questions that are put to them. And, you know, it might be trite, or it might not sound, you know, that relevant to seasoned practitioners doing it every day, but for the person on the street, asking them to listen carefully, asking them to speak up if they don't understand the question, those are all very important notes. I think asking them or letting them know that this is not the forum to air their grievances is also very important. It looks terrible on the record. Any exchanges where they try to challenge the opposing lawyer also looks terrible on the record. And they should know that if a question is not proper, that their lawyer or whichever lawyer is looking out for their interests, they will be the ones to refuse a question, not the witness at issue. Also, just read the materials. For cross-examinations on affidavits, they have to read their affidavits first and foremost. And the witnesses may need to have some or even all of the affidavits, depending on the facts of the case. You know, if they're seeking to rely on documents or notes during their examination, they should be warned that those may be producible. You know, you might be getting into litigation privilege arguments later on down the line, but you want to avoid those types of arguments altogether. And I had cross-examinations on affidavit very recently where I had given the client the advice, you know, take your affidavits and nothing else, have nothing else in front of you. And they had an electronic copy of their affidavits on their home computer. But we're in the Zoom age, and when people are doing examinations at home on their computer, they not only have access to the affidavits, they have access to everything. And what the deponent started to do was look for various documents and files that they had saved on their home computer, which were not referred to in the affidavit. So I would certainly give the client a good warning not to have or to access any additional information other than either their affidavits and what's produced in the affidavit documents.
Yeah, I'll just add to that. One thing I've learned is that no matter how much prep you do, a person is going to resort to their normal demeanor and personality within minutes of an examination starting. So if you have a client who likes to talk and go on tangents, that's what they're going to do. You can try as hard as you want to convince them to avoid that, but it's very difficult for people to move away from their normal way of communicating. And if you have someone who's argumentative and combative, that's what they're going to do. But you still have to try and convince them beforehand that it's not in their best interests, and it's just going to prejudice them in the long run. I also find that dry runs, through the evidence are generally of little value. By all means, you need to discuss with your witness the key issues that are going to be discovered or that are going to be covered. You can talk about, how the witness is going to answer those questions. You can't change, their evidence, but you can talk about, how they're going to address certain issues. You need to ensure that the client knows what to expect, though, so that they're not caught off guard. And, but the most important thing is getting the witness to understand that they have to answer questions directly. If they're evasive, it's going to look very poorly. You don't want them to argue. And you need to, double down on what James said, which is the witness has to ensure that they understand the question. And if they don't, they should ask for clarification. They should know that if you think a question is improper, it's the lawyer that's going to jump in and refuse it or ask for clarification. But if the lawyer doesn't do that, then the witness has to answer. They need to give a complete answer. All right, well, why don't we move on, James, to preparing to conduct the examination. What do you have to say about that?
Sure. I mean, I think they have to know what the scope of the examination is at the outset. So whether that's in an action or an application, the scope is it can be different. It can be the same. The scope of discovery is defined by the pleadings. And if there's any overbroad or speculative discovery, then that's a fishing expedition and it's not permitted. But in an application, your questions must be relevant to the issues on the application or the motion and the matters that are addressed in the affidavit by the deponent. And one of the differences between the actions and applications is if you put something in your affidavit on an application, you can be asked questions on it, even if those issues are irrelevant to the application or the motion. And in preparing for examinations, you should advise the clients that on an action, a party is obliged to inform himself or herself about the matters in issue, and if necessary, to offer hearsay evidence. But on an application or a motion, it's a little bit different. So if an affidavit, for example, on an application is based on personal knowledge only, then there's really no apparent basis for undertakings. And that stems from Rule 39015, which says that an affidavit for use on an application may contain statements of the deponent's information and belief with respect to facts that are not contentious. And you have to set out the source of the information and fact of the belief. But if the affidavit contains information on knowledge and belief, then there is an apparent basis for undertakings in those circumstances. Anything else you'd like to add to that, Greg?
Sure. With respect to a lawyer's preparation to conduct an examination, it's clear that preparation is key. There are no shortcuts. You need to be on top of the issues as defined either in the pleadings or as relevant to the motion or application. You need to know the material documents. And you either need to plan out your questions in advance or at a minimum have a detailed roadmap. Personally, I've been conducting examinations for a long time now, but I still write out my questions. And that said, you need to be ready to deviate from your script. You need to listen to the answers. You need to ask follow-up questions. And most important, you need to ensure that the questions are actually answered. A witness can give a meandering answer that covers a lot of different topics, but if they haven't answered the question that you've asked, you need to bring them back to get your answer. And if a lawyer is arguing with you on the record, which they shouldn't do, about whether a question is proper, you need to make sure that they say the magic words, which is refusal, or this is refused. If they don't say it, you might actually have a court take issue with you moving on it as a refusal. They say, well, it wasn't actually refused. Ultimately, you need to be clear that when you're conducting the examination, it's your record. And you need to ensure that the questions are clear and that the answers are responsive. You don't want to ask compound questions. You don't want there to be any kind of equivocation as to what you're asking. Because if there is, then it means the answer is not going to be as useful as what you would want. And you also need to make sure that you're getting the answers that you need, because when you go back to the transcript, when you're getting ready for trial, you might realize that the grade admission you thought you got was actually unclear or equivocal, and you can't use it. So you don't want that. So the next topic is, unless James, you want to add anything further to that?
No, Greg.
All right. So the next topic is the use of a transcript on an application versus a trial. So I've touched on this briefly already. On an application or motion, either party can make reference to the examination transcripts to support their case or to undermine the other side's case. The transcripts get filed with the court. Helpful evidence from the transcripts should be cited in the factums, and at the hearing, you can take the court to the transcripts and read from them. It doesn't matter if you're reading from your own client's transcript or the opposing side's transcripts, everything is fair game. Now that is to be contrasted with the use you can make of a discovery transcript at trial. Rule 3111 governs what use can be made of a discovery transcript at trial. First, it allows a party to, quote, read into the evidence as part of their own case against an adverse party any part of the evidence given on the examination for discovery of the adverse party, or someone examined in place of the adverse party. So what does that mean? First, it only allows you to read in from the adverse party's discovery. So you can't read in from your own client's evidence as part of your own case, unless your client has died and you have leave of the court. Secondly, it refers to the evidence being read in as part of the party's own case. So what does that mean? It means that it is literally part of your case and the evidence supporting your case. It is on your side of the evidentiary ledger, so to speak. So you don't have to wait for the opposing party to give evidence. You don't even need the opposing party to make a case. You know, if it's a trial that is on default, you can still lead evidence that the other party gave. There's nothing to prevent you from doing that. Now, it also means that because this evidence is being considered part of your case, you would only read in evidence that helps you prove your case. You would not read in evidence that is prejudicial, even if you think the evidence makes the adverse party look terrible. You save that sort of evidence for cross-examination. Now that brings me to the other use you can make of discovery evidence, which is impeachment. If the adverse party says something at trial that is different in a material way from what they said in discovery, you can use the discovery evidence to impeach their evidence at trial, assuming it's in your client's interest to do that. You might like the new evidence at trial, so you have to use your judgment. But there are different ways to impeach a witness. Generally, it involves recommitting the witness to the evidence that they gave at trial, bringing the witness back to the circumstances of their examination for discovery, how they were under oath, how they tried to be accurate and tell the truth, how the discovery took place closer in time to the events in question than their evidence at trial. And then you hit them with the evidence they gave at discovery and how it is inconsistent with the evidence at trial. And you then either get them to acknowledge that the evidence from discovery was correct, assuming you prefer that evidence, or you use the discrepancy to call into question their credibility or their ability to recall the facts. So impeachment can be very powerful. It can destroy a witness's credibility in court and cause the judge to question all of their evidence. And that's why it's very important for you to have a very thorough understanding and recollection and notes of what the opposing party says in their discovery transcripts as you prepare for trial. So James, I think the next topic is Section 13 of the Evidence Act.
Yes, indeed. So if you're involved in will challenge litigation, you will absolutely want to know what this section means and how it operates. Essentially, if a party wants to get a result in a will challenge case, they cannot obtain that result based on his or her own evidence. That evidence must be corroborated by some other material evidence. And the rationale behind that rule, I think the Court of Appeal said it well in Bailey versus Trusts and Guarantee Company. The court always has present in its mind the danger of relying too implicitly upon the evidence of the living in establishing a claim against the dead. So obviously it's an important evidentiary rule for all sides. And the discovery stage of will challenge litigation, that's your opportunity to get that corroborative evidence, which can, enhance the probability that the evidence of your client or one of your witnesses upon a material issue is true. Now, the corroborating evidence can be direct, it can be circumstantial, and it can consist of a single piece of paper or several pieces considered cumulatively. So it's a broadly drafted provision, and it gives the court considerable ambit to receive a lot of evidence that may not otherwise be admissible. And you'll note from the wording of Section 13 that there is no prohibition on hearsay evidence. It is very broadly drafted. And if objections to this corroborating hearsay evidence are made, and I've been in circumstances at trial where they have been made, then the party offering that evidence might find themselves giving legal submissions or having a voir dire in order for a finding to be made regarding the admissibility of that evidence. But if you are in that position, the Canadian courts, as everyone knows, has moved towards the principled approach to evidence. Once you establish that this evidence is necessary and reliable, chances of getting that evidence in have become considerably greater. So that, along with the broad wording of Section 13, I think any party opposing the admission of any corroborating evidence on the basis that it's hearsay is likely to face quite an uphill battle. And that also aligns with the inquisitorial role that courts play when a will is asked to be proven in solemn form. So you have anything you'd like to add to that, Greg?
No, I think you covered it quite well.
Great. So the next portion is we want to talk a little about the examination of the will drafting lawyer, and this is perhaps the most consequential evidence in a will challenge case. Courts certainly carefully consider that evidence. They're neutral, or at least they should be neutral. I've seen cases where the drafting lawyer is a beneficiary in the will, but assuming they're not, they're a third party, they have professional obligations, they're officers of the court, and the court's consideration, notwithstanding all of those factors, will certainly be affected by how well the drafting lawyer documented the steps taken to, ascertain not only capacity, but asking probing questions in respect of, undue influence. And those steps taken should be recorded in the file. When in will challenge litigation, the drafting lawyer's entire file will almost always be producible and produced. So you'll take a good long hard look at the drafting lawyer's notes. Prior testamentary documents will also be producible. But having minimal or sometimes no notes at all, which is often the case, this is troublesome because it invites counsel for the challenging party to question what steps were taken to either ascertain capacity or probing questions for things like undue influence. You don't want to be in a position as a drafting lawyer where you're relying on memory. That's not a good place to be. So, everyone knows a drafting lawyer has a duty of care, but the real question is, did the drafting lawyer fall below the standard of care? That was set out by the Supreme Court in Central Trust Co. v. Rafuse. I think I'm saying that correctly. And the standard is reasonable care, skill, and knowledge to the task which they have undertaken. And that's been referred to as the reasonably competent solicitor or ordinary prudent solicitor. So when you're asking questions of a drafting lawyer, obviously ascertaining capacity, what steps they took, what probing questions they asked, and what their instructions were for drafting the will, why there is a paucity of notes, if that's the case. And proper questions also include the nature of the drafting lawyer's experience. I always ask those questions. I've never been refused any of those questions. Such as, what percentage of their practice is devoted to estates and trusts? How long are they practicing? When were they called to the bar? But I have heard from some leading practitioners who say that those types of questions are strictly irrelevant. They argue that it does not matter whether a drafting lawyer is more or less experienced, whether they've drafted 1 or 100 wills. There is but one standard of care for estates lawyers in Ontario, and either you met that standard or you didn't. That's something to consider. And my final comment is, remember that the drafting lawyer is being asked questions as a fact witness. They're not there as an expert, even though they would profess to have expertise in that area. And consider Rule 3106, which requires a witness to answer questions to the best of his or her knowledge, information, and belief. So always exercise caution when asking a drafting lawyer about their quote unquote opinion. And the courts have held, and we can share the citation if you wish, that a drafting lawyer can be asked to explain their understanding of the appropriate professional standard. But it's not a proper question for a deponent, no matter which profession is an issue, to be asked to render their opinion on the standard of care. Such opinions are reserved for expert witnesses. So a classic example of that type of question, do you believe you fell below the standard of care? That's obviously a legal question. It should be refused. If it's answered, the answer you're probably going to get is no. But again, it's not a question for that day. Greg, anything else you've considered helpful when examining a drafting lawyer?
Sure. With respect to the debate as to whether a lawyer's experience is relevant in this type of situation, I would just say the fewer the notes they took, the more they rely on, well, that's my practice, the more you need to get into what their practice is, what their experience is. And, a lot of drafting lawyers are not familiar with the legal test for testamentary capacity. So, they'll go in and they'll talk to the testator, they'll take instructions, and they'll draft a will. And, in many situations, that's fine, and nothing is ever going to turn on it. But the instructions for what goes into a will don't necessarily tie in to the test for testamentary capacity. In my experience, very few lawyers have the more in-depth discussion with the testator to make sure that they actually understand the extent of their assets. They don't go into, well, what do you actually own? What assets are on your name? What have you done with other assets, so that they have an understanding? Does this person really know what they're giving away? Does this person really know who they are giving the assets to? Well, who is this person that you're giving the residue of your estate to? So you really need to pay close attention to those notes. And if in their evidence they say they asked, general questions, well, you really need to challenge that and get the details, because unless you're asking the right questions, then your own personal view of the testator's capacity is irrelevant.
Yeah. And on the issue of the drafting lawyer's experience, I found that it's a double-edged sword, because I've had a case where you get the 1 page of scrawled handwritten notes, and you're asking the drafting lawyer whether or not they've drafted many wills before. And if they've drafted hundreds of wills, then you can question whether their memory is going to be so good with respect to this case. But the answer I got was they drafted 2 wills. So I think a court is much more likely to believe a lawyer's recollections if the amount of wills that they've drafted is considerably less. But a drafting lawyer simply has to take good notes. It takes time. It takes time out of your practice, but it's part of your professional obligations to your client as a drafting lawyer. And anytime you do it, it should be docketed. You should explain to your clients that this is necessary. If this is the will that you want to be a valid subsisting will, it's not just what goes into the document. It's all of the notes and substantiating note taking, which will ultimately ensure, or rather give the best possible chance of that will surviving. So don't be afraid to explain that to your clients and to show them how important all of that really is.
Yeah, there really is a lot potentially riding on the evidence of the will drafting lawyer. It's not just to support, the will. It's also to allow everybody to understand exactly whether that testator really was, having capacity. So it's important for both sides to conduct that examination and to ask the right questions and get to the bottom of whether the lawyer really is in a position to give useful evidence as to what the person's capacity was. So I think given the time we should open it up now to questions, and maybe Peter or Maddie, you can come back into to help moderate that.
That's great. Thank you very much, Greg and James, for that presentation. Really, really helpful, and a great presentation on a really important piece of will challenges. We've got a few questions in the chat. If other people have questions, feel free to either put it in the chat, or you can unmute yourself and just interrupt and ask. That's fine too. I see a couple questions in the chat right now, so I'm going to go through those. The first one has to do with Section 13 of the Evidence Act. The question is essentially this: is that if there's a issue about the admissibility of evidence because of Section 13 on the Evidence Act, and that issue comes up during an examination, let's say a cross-examination in this case, is that something that the lawyer that is objecting to the admissibility of that evidence, is that something that they should raise during the cross-examination, or is it something that they can wait until you actually have your hearing before the judge to raise? Now, my personal opinion on that is, well, it's a legal argument. I think that if someone's, saying something that is not going to be sufficient to corroborate their, the evidence regarding, their entitlement to an estate, then you could probably save that for your factum and your oral arguments. But I'm wondering if Greg or James, you have a different opinion on that.
So it depends if you're talking about a trial or an application. If it's a matter that is going to trial, ultimately the trial judge determines admissibility. And if you are simply conducting an examination for discovery and it's covering evidence that you think is objectionable, I would say you are not going to be held to either making an objection or not making an objection and having it be binding on you at trial, because the trial judge ultimately has to determine the admissibility of the evidence that's being heard. So if you didn't object to something on a discovery, it's not going to stop you from objecting to it at trial. In a cross-examination, in an application, you might want to get that objection on the record, but ultimately, it's going to be difficult to do anything about it unless you are refusing the question. And if you're refusing the question in a Section 13 context, you are inviting a refusals motion and delays. And if you're wrong, there could be cost consequences. And at the end of the day, as James said, this evidence in a civil case, in a will challenge case, it's going to be allowed in. The question is what weight the judge is going to give it. So on an examination out of court, you can make your position known on the record, but in court is when you are going to have to make the argument as to the admissibility.
Yeah, I think you're stepping into the role of the trial judge by making those types of arguments during an examination. That's for the trial judge. But if I wouldn't get into an argument on the record. State your position, and you would either argue about it on the refusals motion or a trial.
Right. Thank you both. I've got another question here about, an important question. It's, do you have any recommendations for what a best practice would be for providing evidence in your file that you've inquired into testamentary capacity? Again, for me, I would think the answer is look up the test for Banks and Goodfellow and really tailor your questions to that test. And I think that's going to go a long way. The Banks and Goodfellow test is, of course, the test to determine whether someone had testamentary capacity to understand the will that they were signing and giving instructions on. But, you know, perhaps Greg or James, you've got some other input in this.
Understanding the test for testamentary capacity guides the drafting lawyer as to what the court is going to consider when it comes to capacity. So asking questions that go to those specific points is really key. And of course, making notes about the questions you asked and the answers that you received.
Yeah, there are more detailed lists of questions. Obviously, the Banks v. Goodfellow test is a super start. We have some sample lists of questions on our website. There are many lists of sample questions online. You should, you know, print them off, have them in a file, and just go through them. They're a super resource.
Great. Thank you very much. To the extent that someone else has any other questions, feel free to ask them, you know, orally now, or you can put them in the chat.
Peter, I see that Charles Wagner has a question.
Go ahead, Charles.
Justin, also in response to the last question raised, you should make a distinction between open and closed questions when you're trying to determine capacity. Often people camouflage their incapacity by answering yes and no questions pretty easily. But when you ask them open questions, it's different. I have a question to the presenters about discovery. Imagine the scenario where there is a refusal. Is it appropriate to ask counsel on the record to explain the grounds for their refusal? And if it is or isn't, tell us why.
Well, technically, when you refuse a question, you are supposed to give a brief explanation for the basis of the refusal. What can sometimes get frustrating is when a lawyer refuses to answer a question and then goes on a long-winded argument about, you know, relevance, in which case, you know, after a while, you just have to thank them and ask them to stop.
I always try to, whenever I give a refusal, briefly state the reason, which I think is how the rules say you're supposed to do it, and don't get into argument about it.
And have you found when you do that and you have a refusals motion, what the other counsel said on the record helps you?
That often doesn't matter. If a lawyer changes the basis for their refusal at the hearing of the motion, the court is just going to consider that. And sometimes a lawyer will not give a basis for the refusal. If it's refused, it's refused. There's not much you can do about it except either use it against them by asking the court to draw an adverse inference if the court is willing to do that, or by pursuing a refusal motion.
Thanks.
I would ask the lawyer who is refused, if they don't provide a basis for the refusal, which often doesn't happen, you should request one for the purposes of the record.
Thank you both all very much. If anyone else has another question, feel free to ask it now. Right. I think this is a good time to end it here. Thank you all very much for attending. As a reminder, before you leave, the certificate of attendance is in the Zoom chat, so please download that before you go. We're going to take a bit of a break between now and our next seminar. I believe our next seminar is going to be on September 6th. Maddie, you can correct me if I'm wrong on that. The topic is going to be mediation in will challenges. So we look forward to seeing you then. Enjoy the rest of your summer.
Thank you, Peter. Thank you, everybody.
Thank you, everyone.
Thank you.